Welcome to Dr. Jae Francis Immigration Channel. Hi, I'm attorney Jae Francis. I'm a U.S. immigration lawyer based in Chicago, but serving all 50 states. Today, we're diving into a critical topic for DACA recipients: how to navigate the complex pathway to permanent residency in the United States. With a recent Fifth Circuit Court ruling putting the future of the DACA in question, it's more important than ever to understand your immigration options. Number one, the unique challenges DACA recipients face. Many DACA recipients came to the U.S. as a children without being admitted or parole. While DACA offers protection against deportation and work permit, also prevents accumulation of unlawful presence, it does not grant legal immigration status. According to the Immigration and Nationality Act, Section 245A, a lawful entry and legal status are required to adjust your status to permanent residency. Simply, DACA recipient, because they didn't enter the U.S. with admission or parole, in some cases has unlawful presence, then there is an issue. They need to get married to U.S. citizen, but there is extra step. Adding to the uncertainty, the Fifth Circuit Court recently upheld a ruling that DACA is indeed unlawful, allowing only temporary renewals for current recipients, only renewals, including for those of you who live in Texas. New DACA applications remain blocked, and program's fate likely rests with the U.S. Supreme Court. Given this, it's vital to explore alternative immigration options to secure stability and pathway to permanent residency. In this video, we'll cover 4 proven pathways to permanent residency for DACA recipients. I'm going to list them first. Adjustment of status through marriage after DACA Advance Parole, CR1 Spouse Visa, 601A Waiver, and military parole in place. I'm going to break down each option for you. Number 2, adjustment of status through marriage after DACA Advance Parole. If you are married to a U.S. citizen and have trouble on advance parole, you may qualify to adjust your status to permanent residency. Advance parole allows DACA recipients to re-enter the United States lawfully, meeting the requirement for adjustment of the status. What are the steps for this option? Number 1, you need to travel overseas on advance parole. Obtain advance parole through I-131 and re-enter the U.S. lawfully. Then file for adjustment of the status. You can submit I-130 and I-45 together concurrently with your U.S. citizen spouse. If there is an interview, you'll be attending interview before USCIS adjudicate your case. The key benefits of these options are you don't need to leave the United States for consular processing, or it means consular interview. Basically, in most cases, you will go back to your home country to visit ailing relatives dealing with some medical conditions. But it's not interview. Interview is not required. Also, it is relatively faster processing than other options. But at the end, you need to leave the United States and then come back. Excellent option. But be aware that if Trump or Supreme Court held that DACA is indeed unlawful and cancel the program, the DACA Advance Parole will be gone as well. So time sensitive. If you haven't explored this option, it is right time, high time. You need to do it now. Number 3, CR1 Spouse Visa or F2A Spouse Visa. Now, DACA Advance Parole is not available to everyone, every DACA recipient. Sometimes 3 grounds for DACA Advance Parole, namely humanitarian, educational, or work grounds or justifications, aren't there for you. So advance parole is not for you, or Trump or Supreme Court struck down DACA and thus advance parole. If that's the case, then you have a different option. But this is something that you need to listen carefully, because there is a strict requirements you need to meet in order to pursue this option. And more than any other options, 601A waiver is something that you need attorney. I will say that all options you need to work with attorney, but this is very tricky. Okay, so you need to be careful. So if you began DACA before turning 18 and have no unlawful employment record, the CR1 Spouse Visa might be your best option. Why? Because DACA prevents accumulation of unlawful presence, and all unlawful presence before turning 18 do not count, and also no unlawful employment before obtaining DACA or turning 18. Eligible recipients will not trigger 3 or 10-year entry bars when leaving the United States. So as you can see, this option requires consular processing and interview compared to DACA Advance Parole. So I'm going to repeat eligibility requirements one more time. You must have started DACA before age 18 and renew it continuously. There is no gap between previous and next DACA renewal. You must have lawful employment only. There is no break. There is no unlawful employment at any time. Also, no unlawful employment before age 18 and any time, in fact, any time. And also, you need to get married to a U.S. citizen or lawful permanent resident. If you get married to a U.S. citizen, then it's a CR1 spouse visa. It's a faster. If you get married to permanent resident, it's called F2A, but it's going to take 3 to 5 years. It's a lengthier process. I'm going to break down the processing overview. You start with filing I-130 petition with your spouse. It can be U.S. citizen or permanent resident. As I mentioned, that if you file I-130 with a U.S. citizen spouse, it's faster than those filed with a permanent resident. When I-130 is approved, then your consular processing starts, National Visa Center process, and you'll be attending interview at your home country. So key point, there's an interview. And then when consular post approves your case, you come back to United States with an immigrant visa, and within 30 to 60 days, you get a green card. Excellent program. Number 4, 601A waiver. Previously, I talked about Advance Parole and also CR1 Spouse Visa. This option is only available option if you have accrued more than 6 months of unlawful presence. Remember that if you have between 6 months and 1 year of unlawful presence, then you're subject to a 3-year bar. If you accrued more than 1 year of unlawful presence, you're subject to a 10-year entry bar. Thus, you need a 601A waiver to overcome unlawful presence. So this is a key point. If you don't have up to 6 months of unlawful presence, then you may try CR1 Spouse Visa. But if you have more than 6 months of unlawful presence, then you need to go with 601A waiver. This 601A waiver provides a solution to avoid penalties associated with consular processing. Now, President Obama introduced this 601A waiver. It means that you'll be in the U.S. until interview is scheduled in your home country. Previously or otherwise, you need to have an interview first in your home country, then you need to do 601 waiver in your home country. So you're kind of spend more time in your home country without 601A waiver. So who qualifies? You're married to a U.S. citizen or lawful permanent resident. Remember, if you get married to a U.S. citizen, your case will go faster than those of you who got married to permanent resident. You should be able to demonstrate that your spouse would face extreme hardship if you're unable to stay with your spouse or have to go to your home country. What are the steps? You file I-130 petition with your U.S. citizen spouse or permanent resident spouse. When it's approved, then you submit 601A waiver to USCIS, and then still you're in the United States. When the waiver is approved, then your consular processing starts, National Visa Center, and consular interview. When the consular post approves your case, then you come back with an immigrant visa, and then 30 to 60 days later, you'll get a green card. This one is most challenging because you need to show extreme hardship to your spouse, and this takes longest. This is a lengthy process, but still, it's a good program. Even Trump will not be able to take away this option. So very good option. Number 5, military parole in place. We call it PIP. If your spouse is serving in the U.S. military or is a veteran, you may qualify for military parole in place. This program provides lawful presence, making it possible to adjust status without leaving the United States. So remember, the 3 previous options that I explained require you to leave the United States, right? DACA Advance Parole, no interview, but you need to leave the United States. Second one, CR1 Spouse Visa, and the third one, 601A waiver, both require you to have a consular interview in your home country. But this one, military parole in place, does not require you to leave the United States. So what are the benefits? Sounds really good, right? It offers protection from removal while the application is pending. Now, if we're talking about military parole in place for DACA recipients, I mean, it's not really new protection because DACA also offers protection from removal, but still good to have it. And then, you may not have a DACA or expire, and then you'd like to explore military parole in place. Very good protection, especially considering that Trump will execute mass deportation. You need a protection from removal. Also, you're eligible to adjust your status to permanent residency, right? Without advance parole or without leaving the United States. What are the steps? Number one, you need to apply for parole in place. You submit I-131 application. Then when it's approved, then you apply for adjustment of the status. And still, like I said, you're in the United States. Excellent program. So far, we review 4 different proven options for DACA recipients. With the future of the DACA uncertain, now is the time to secure your path to permanent residency. Contact us. Contact Francis Law Center, which is my law firm, to schedule consultation, case evaluation. Start your journey today. Staying informed, knowing your rights, and preparing in advance are essential to protecting yourself and your family more than ever. Thank you so much for watching. If you found this video useful, please like, share, and subscribe for more updates. I do live stream every Thursday, 5 p.m. Central Time. Also, I plan to do it on Tuesday, 5 p.m. Central Time as well. You can also find me on TikTok, Instagram, Facebook, LinkedIn, and our website, francislawcenter.com. At Francis Law Center, we're here to stand by with you every step of the way. Stay safe. We'll see you in the next video. Peace be with you.